I'm Bill Peterson, Minnesota estate planning attorney. One of the most important pieces of a person's estate plan is the healthcare directive. Sometimes these are called living wills. Simply put, the healthcare directive, or HCD for short, spells out how a person wants to be cared for when they become disabled. I say when they become disabled because, first of all, people are 6 times more likely to become disabled in any given year than to pass away. We will all become disabled at one point in our lives. It could be the last 20 minutes of our life or the last 20 years. Because of the risks of disability, it is wise to have your health care wishes stated in a legal form. This is where the healthcare directive comes into play. The healthcare directive will state the treatments or procedures you would like once you become disabled. Additionally, the healthcare directive will state the treatments or procedures you would not like to have. In fact, sometimes stating what you do not want is just or more important than listing what you do want for treatments or care. Since it is such an important document, the healthcare directive should be reviewed every 3 to 5 years. Just like a will or trust, the healthcare directive may need to be updated. Here's a list of 6 ways that a healthcare directive may fail. Number 1, the healthcare directive may not be in the doctor's hands. This is a question of accessibility. When the time comes for you to use your healthcare directive, you may not be conscious. If that's the case, you will want your healthcare directive to be in your doctor's hands when you arrive at the hospital. In fact, this is a simple step that many people do not take, which can lead to your wishes being ignored when a new healthcare directive may be created on the site. Number 2, if the healthcare directive has no HIPAA provisions. An incredibly important document that should accompany your healthcare directive is a HIPAA authorization. HIPAA stands for the Health Insurance Portability and Accountability Act. Now, this HIPAA authorization authorizes other loved ones to receive updates on your treatment status. If you are an elderly parent, you may want your adult children to know about your health condition. Number 3, a healthcare directive that is not properly written. A healthcare directive that is poorly drafted will not get better with age. Different people want different options when it comes to deciding their healthcare choices. Usually, what's sometimes called a template healthcare directive generally will not meet those choices. Number 4, that the healthcare directive lists the wrong parties. The persons whom you designate on your healthcare directive should actually be the people you want to make decisions on your behalf. Surprisingly, I have seen many healthcare directives that spell out the wrong people, which can create severe problems for the care that you do receive at the clinic or hospital. Number 5, a healthcare directive that is old or out of date. Now, what happens when a person you designate as your agent, perhaps 17 years ago, has already passed away? Or what happens when your agent has moved to California and won't be able to travel back to Minnesota? An out-of-date healthcare directive is a ticking time bomb that can hurt you and your family severely. Number 6, a healthcare directive that's been revoked by accident. Well, yes, this happens. In fact, it can happen quite easily. Here's how. If the doctor at the emergency room asks your spouse or child about a healthcare directive, and that spouse or child is unsure about it, They may have you sign a new template healthcare directive right in the emergency room lobby. Now, chances are this template healthcare directive may not be the same as the well thought out version that you completed with your attorney at a time when you were peaceful and sound of mind. A healthcare directive is an essential part of most people's estate plan. However, it must be reviewed regularly to ensure that it continues to protect you as you want it to. It's a good idea to talk with an experienced estate planning attorney and who can help decide what is best for you. I'm Bill Peterson, Minnesota estate planning attorney. If you have a healthcare directive that needs fixing, I can help. If you don't have one, I can help with that as well. Call me at 952-921-5818 for a free, no-obligation consultation. Thank you, and have a great day.